Hey folks, Bebop Oluller here, and today we're looking at a very tawdry story, but unfortunately not at all uncommon. I'm talking about the rock star and the young female groupie. A tale as old as the music industry. The reason I am featuring this one is because it is still scheduled to go to trial in 2026. But the hype and misinformation going around social media about this particular case has been insane. What we are going to do is look at the plaintiff's allegations and the respondent's defense. Sensitive viewers, please note. This lawsuit involves allegations of rape, sexual abuse, and abortion. The voice behind Aerosmith's Dream On, Mr. Steven Tyler himself, born Steven Victor Tyler, is being sued for events that allegedly happened half a century ago. The plaintiff is Julia Misley, born Julia Holcomb. The question that I want to explore amongst many in this sordid tale is one of Tyler's defenses. Can guardian immunity shield you from being charged for sex with a minor? I'm calling this Julia and Steven. I'm Bebop Oluller, and you're watching I Fought the Law. In 1973, Julia Holcomb, then 16 years old, met Aerosmith frontman Steven Tyler after a concert in Portland, Oregon. According to her lawsuit, Steven Tyler, 25 at the time, invited her backstage, asked her age, and then began what she describes as a manipulative sexual relationship that lasted several years. In 1974, Tyler allegedly convinced Julia's mother to sign papers making him Julia's legal guardian so that Julia could travel with the band. Julia says that this guardianship enabled Tyler to transport a minor across state lines, an otherwise serious federal offense. She says he promised schooling and medical care but instead gave her drugs and alcohol. When she fell pregnant with his child, Julia claims he pressured her into having an abortion. In 2019, Julia Misley used California's 2019 revival window law, which allowed survivors of abuse to sue their attackers despite expired time limits. This window reopened her chance to file against Tyler. She sued in the Los Angeles Superior Court. Misley is represented by Jeff Anderson and Associates, a law firm well known for representing victims in historical child abuse cases. Click the link to read the original application. Although this is a civil case, Misley's complaint leans on California Penal Code Section 261.5, which, among other offenses, deals with the rape, abduction, and carnal abuse of children. Unlawful sexual intercourse with a minor is often referred to as statutory rape. I don't like that term. It almost suggests that this is a lesser form of rape. I disagree. Rape is rape, one of the most awful crimes a person can perpetrate on another person. The difference here is that the victim is not kicking and screaming or fighting back and repeatedly saying no. The law says that a child does not have the capacity to understand the full ramifications of sex, and an adult needs to respect that. Therefore, even if the child victim's behavior suggests they know what they are doing, the law says they do not and cannot, irrespective of the circumstances. Misley also relied on related statutes covering sexual battery and emotional distress, but I will concentrate on the rape charge. As is usual in these cases, Tyler pleaded consent. Let's deal with that. Penal Code 261 says consent means positive cooperation in act or attitude pursuant to an exercise of free will. The person must act freely and voluntarily and have knowledge of the nature of the act or transaction involved. A current or previous dating or marital relationship is not sufficient to constitute consent if consent is at issue in a prosecution under the code. We must assume that the trial judge will throw that one out quickly. The fact that Julia was 16 at the time means she did not have the legal capacity to consent to sex. Even if she did say yes, Tyler should have said no, because you're only 16. Instead, Tyler published his memoir, Does the Noise in My Head Bother You?, in 2004, where he remembers that first encounter. The lawsuit says the singer confessed to his alleged crimes when he wrote,
She was 16. She knew how to nasty, with my bad self being 26, and she barely old enough to drive and sexy as hell. I just fell madly in love with her. She was my heart's desire, my partner in crimes of passion. I was so in love, I almost took a teen bride. I went and slept at her parents' house for a couple of nights, and her parents fell in love with me. Signed paper over for me to have custody, so I wouldn't get arrested if I took her out of state. I took her on tour with me.
but Tyler also raised a novel defense. In his March 2023 answer to Misley's complaint, Tyler raised a guardian immunity defense, claiming that because he was her legal guardian, some form of immunity applied. That document is public. You can read it on the Anderson site. So what does Tyler mean by an affirmative defense? Under California's Code of Civil Procedure, an answer must include a statement of any new matter constituting a defense. That new matter is the affirmative defense. The defendant must plead it specifically, or the court will not consider it. Once raised, the defendant bears the burden of proof on that defense. An affirmative defense admits the facts but says, even if that's true, the law protects me. It's like saying, I did it, but I'm legally allowed to. Or, yes, I did it, but the law can't touch me. Tyler seems to be arguing that as her guardian, he was legally entitled to have sex with Julia despite her being a child. The courts can strike out an affirmative defense if it has no basis in law. So, could guardianship possibly shield someone from sex abuse liability? California's probate code lays out what a guardian can do: custody, education, medical care, all the ordinary parental powers. But nowhere does it say that a guardian can have a sexual relationship with their ward, which is hardly surprising as a guardian is essentially a parent to their ward, what the law calls in loco parentis, which means in place of the parent. It goes without saying that actual parents are not allowed to have sex with their children, and therefore by analogy this should apply to guardians as well. In addition, California's Family Code 6500 defines a minor as anyone under 18, and remember that Penal Code 261.5 makes any sexual intercourse with a minor illegal, consent or not. I would argue that guardianship doesn't create immunity. Quite the opposite, it actually heightens the duty owed by the guardian to their ward. It is a common principle of criminal law that when the adult is in a position of authority, trust, or guardianship, the law imposes harsher penalties if they commit a crime on a child. In other words, that sexual acts committed by a person responsible for the care or custody of a child would constitute aggravated sexual offenses. Whilst the criminal law is quite clear, we must not forget that Julia Misley is suing Steven Tyler. Personal injury claims are different from criminal lawsuits in that they are civil in nature. Civil lawsuits do not end in the defendant being imprisoned. Instead, if you win, you will be awarded punitive damages, which is monetary compensation, to cover medical, therapeutic, psychiatric, and therapy costs, as well as to compensate the victim for physical pain and distress, and mental anguish. It could also be argued that even outside criminal law, a guardian having sex with his ward is a breach of fiduciary duty. The California Probate Code says that where a guardian is liable for a breach of fiduciary duty, this does not prevent resort to any other remedy available against the guardian or conservator under the statutory or common law. In other words, you can sue both for the breach of duty and any other wrongs committed against you. This, of course, assumes that Tyler was actually a legal guardian to Julia. As the details on this are scant in the plaintiff's complaint, it is hard to know. Tyler describes the process thus: her parents signed paper over for me to have custody. The important thing to stress here is that a guardian can only be appointed by a court. Even where the parents have nominated a guardian for their child, the court must approve that appointment for it to be valid. On the facts stated, it is possible that Julia's parents signed a written agreement, a sort of specialized power of attorney, giving Tyler the authority to care for their child if they knew they could not take care of her temporarily. In this type of agreement, a parent can give you the right to make any decision for the child that a guardian would be able to make under the law. The agreement must list each decision you are authorized to make in writing. You will not have the right to make any decision that is not listed. For example, the parent might want to give you the right to make decisions about the child's medical care and education, but not the right to change the child's residence or consent to the child's marriage. This agreement can give you rights to care for the child, but it will not give you legal custody over the child. The parents will keep legal custody and all their rights to make decisions about the child's life, too. Only a court order, like a guardianship, can take legal custody from a parent and give it to another person. In addition, a parent can cancel this agreement or power of attorney at any time. If there was such an agreement, and if it claimed to give Tyler permission to have sex with their minor child, which is highly unlikely, it would in any event be unlawful and therefore unenforceable. Tyler has since abandoned that defense, which is hardly surprising. According to Misley's filing in August of this year, Tyler now testifies that he does not recall the guardianship. In his latest application for summary judgment, Tyler argued that Misley is a non-California resident wrongly invoking California's childhood sexual assault revival statute to sue over a consensual relationship that took place while they were living together legally in Massachusetts, where the age of consent was 16. He said that if the court rejects that argument, at the very least, the case should be limited to alleged conduct in California, because any possible claims in the other states have expired. In reply, Misley argued that public policy doesn't support rewarding someone who intentionally brought a child to a state with less protection. She argues that her case qualifies for the California revival statute, and Tyler's alleged actions throughout their relationship should be fair game. She says it would be impossible to separate her claims into 4 cases in 4 states. That application is presently down to be heard in December, with the final jury trial set down to start on the 31st of August 2026. Click on the link for the full trial itinerary. I'm Bebop Olulur, and I'll see you next time on I Fought the Law.